we wait to change that after you.
Thank you. And you can see that this mic is
That's
working.
your mic.
Yeah. It'll be that one, that one. I mean, it's one or two.
Just wanted to.
Yeah. Far left are the main mics. Then the next two are these.
So it's not used right now.
No. All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning. Welcome to your North Carolina Court of Appeals. My name is Chris Dill, and I'll be presiding. And to my right is Judge Legger Collins, and to my left is Judge April Wood. Jean Soar is our clerk, and our marshal today is Richard Remillard. We have one case on the calendar today. It's Dismas Charities versus the City of Fayetteville. And if the appellant is ready, you can proceed. And just let me know if you want to reserve any time. I'll keep your time up here. I'm a little bit looser than maybe some other judges, because if we're in the middle of firing questions at you toward the end, we don't hold that against you. So just let me know initially just how much time you want to reserve.
Yes, Your Honor. Your Honor, would you mind if I remove my face cover?
Yeah, you can remove your mask. You're not bothering me.
Thank you. May it please the court, my My name is Amy Kraut, and here with me today is John Cook. We represent petitioner appellant Dismas Charities. We would like to reserve 6 minutes for rebuttal.
Okay.
Dismas Charities is a nonprofit organization that has successfully operated reentry programs for state and federal offenders for approximately 55 years. It now operates 33 facilities in 14 different states across the U.S. Dismas has developed a proven track record of being a valued neighbor, community member, and corporate partner wherever it locates its programs. This appeal arises from Dismas' request for a special use permit to operate what is classified as a halfway house on property it purchased within the city limits. The primary question before this court today is whether the Superior Court erred by concluding that Dismas failed to produce a prima facie showing of entitlement to a permit based on its conclusion that it was bound by the denials finding 19, which is actually a conclusion of law, holding that Dismas failed to produce sufficient evidence to satisfy Standard 7 of the special use standards. That is, that the special use would allow for the protection of property values and the ability of neighboring lands to develop the uses permitted in the zoning district.
Let me ask you a question. Is the burden just to show what you would have to show at a directed verdict? Is that correct?
It is, Your Honor.
So if you produce evidence, what opportunity does the other side have to produce evidence? Because does the city council have to take it in the light most favorable to you, and they have to ignore all the other evidence? How does that, I'm trying to understand how that works. I mean, what opportunity does somebody opposing the permit have to do anything if you're saying everything must be taken in the light most favorable to your clients?
Your Honor, I think the court answered that in PHG Asheville, the North Carolina Supreme Court. This is a two-step process. The first step is that the applicant must show a prima facie showing. The standard that all parties agree to is that is a directed verdict. If there is a prima facie showing, the second step becomes, is there other competent material and substantial evidence to support not issuing the permit?
And the council can consider that in making their final decision. Is it your take that, is it your contention that they just never got to that second step because they said there wasn't a prima facie showing? Is that
correct? There was no prima facie showing, and even if there is no contra evidence in the record to contest it.
Would you agree that under NC Gen Stat 160A, 393K3A, you were required to present expert testimony as to Standard 7?
Your Honor, 393K3A is an evidentiary standard that is actually based on the scope of review. It is what the City Council is allowed to rely upon when making a decision on the permit. And it specifically deals with what is competent evidence. In this case, the General Assembly has deemed that competent evidence is all evidence, 1, admitted without objection, or 2, evidence that could be reasonably relied upon by the council in making its decision. There are only three exceptions to this rule, and that's lay opinion testimony, and specifically in this case, it would be affected to the property values. Here, the Standard 7 does not require expert testimony to prove the facts and conditions to be entitled to a permit.
what does Standard 7 require? Because it says it just has to allow for the protection of property. Does that just mean some protection? Because I guess if you put forth evidence that we're going to build a new building that looks nice, that would provide some protection, even though we wouldn't know if it would provide total protection because property values still may go down. But would that satisfy Standard 7, or who makes that call what Standard 7 means?
Your Honor, admittedly, Standard 7 is not the traditional standard that is adopted in North Carolina when considering whether a special use affects property values. That's typically the Keenan standard, which has been interpreted by this court several times. And that's the use will not substantially injure the value of the adjoining or abutting property. Here, despite the obvious differences between the language of Standard 7, it's a two-part standard. First, that the special use would allow for the protection of property values and allow the ability of neighboring lands to develop the uses permitted within the zoning district. Despite the obvious differences, the city and intervener's brief don't present a separate interpretation or analysis of the facts and conditions required to show Standard 7, but it's actually argument that they did on multiple occasions. That being to satisfy the Standard 7, Dismas had to show through the layout on the property, the design, building materials, and aesthetics that both of those two pieces. In essence, what it comes down to is when designing and conceptualizing the ways in which the property would be used, would Dismas Charities take into account the particular nature of the surrounding areas and the sensitivities thereof? This interpretation is consistent with state and city law, including the well-established principle that government regulations are construed in the free use of property, but also the city's general provisions that require Standard 7 to be interpreted in accordance with the Development Ordinance's general purposes, which specifically emphasize design, quality, and a single unified purpose to maintain and protect high-quality aesthetic standards for development and to conserve the values of building and land. So again, admittedly a different standard. We argue that it doesn't require appraisal, but that all of Dismas Charities' evidence goes to show that allows for protection of property values, and it allows for the ability of neighboring lands to develop uses permitted in the zoning district.
Yeah, go through real quickly what the evidence was you say is substantial evidence that supports that they satisfied 7, besides, okay, the design, the materials, and all that the building would look nice.
Absolutely.
What evidence was before the council?
Initially, prior to the public hearing, Dismas Charities produced an application and several updates. This application included 100 pages of information for the city to review, specifically showing the Standard 7. First is Dismas's direct response on the application form that it complied with Standard 7 based on the construction, attractiveness, high quality, and commercial grade of its building. It produced 5 pages of statements from community leaders where other Dismas Charities facilities are located, stating that it has a reputation for leading by example by beautiful renovation and upkeep of their building and grounds, and establishing Dismas as integral parts of that community, allowing for the protection of property values, allowing for neighboring lands to continue to use their property as permitted in the zoning district. And also, and specifically we have here today, and I apologize, the plexiglass made the easel a little bit more difficult.
Oh, that's okay.
But we have the site plan that Dismas Charities presented. And here you'll see that Dismas Charities put a 10-foot landscape buffer around the entire property. They did a 225-foot wooded natural buffer between the edge of the facility and the residential uses. They established a fence at the top between the facility and the adjacent properties here, and actually agreed to the Doves that they would establish a fence between their property and the Doves' property as well. In addition, they made sure in designing and considering the surrounding areas that the facility faced the main road, the parking lot is private, and that no traffic goes on the side road that connects to the residential area on the end.
Let me ask you one more question about directed verdict standard. Because in a trial, the judge gets to determine whether or not there was enough evidence from which the jury could make the finding. But then the jury, even if the other side presents no evidence, the jury can still say, I don't believe that. So here, if we find that there was a prima facie case was made, if nobody else presents any other evidence, can the council still find against your client by just saying, that might make a prima facie, but we just choose not to believe it? Could they put their jury hat on? Is there a jury hat that they would put on after they would determine as a judge, yeah, you met your prima facie case, let's hear if the other side has anything, and if they don't, we can still, as a jury, say we don't believe you?
I think the holding of PhD Asheville is clear that if the applicant shows a prima facie showing of entitlement to the permit and no other contra evidence is issued, the permit must be issued.
As a matter of law, okay. So that makes it a little bit different than, I guess, a directed verdict standard. Okay, thank you.
You're welcome. In addition to the Standard 7 and the interpretation that we just went through, we'd also argue that the Superior Court erred by failing to consider this unique requirement of city law that requires a determination of completeness before the application is even presented to the City Council. It's an idiosyncratic requirement that the city staff has to determine that the application included the information in sufficient detail to evaluate the application to determine whether it complies with the appropriate substantive standards of the ordinance. This determination is important for two specific reasons. First, it shows the high burden that the city places on an applicant. An applicant must do all of its homework, showing that everything in their application meets the substantive standards of the ordinance before it gets to the City Council. But also, and almost more importantly, by requiring the city staff to make this determination, it puts the applicant on notice of the facts and conditions required to satisfy the city's 8 special use standards, including Standard 7, whether the special use would allow for the protection of property values and the ability of neighboring lands to develop the uses permitted in the zoning district. Going back to PhD, this concept of notice to the applicant and what Standard 7 requires is essential, because if the applicant does not have notice of the facts and conditions that they are required to prove, then a city cannot make a determination that they did not meet that standard or base a determination that they should deny the permit.
So is it your argument that because that application was deemed complete, that the city had to then approve it unless there was contra evidence? Is that what you're saying?
At the very least, the completeness requirement determines that the applicant was put on sufficient notice of the requirements of Standard 7. So in this case, the city staff, the zoning commission, and the technical review committee all interpreted and applied Standard 7 to mean what we went through previously, that the building's layout, the design, the building materials, and aesthetics satisfied that standard and could move forward to the next step. And that is where you get to what happened at the public hearing.
But just because they say that it's complete doesn't necessarily mean that the city has to approve it, correct? There is some sort of evidentiary hearing. That's not a hearing at the application level, correct?
We would argue in this case the city delegated some of its discretion by requiring a completeness determination. Specifically, when Standard 7 is a little bit different than the Keenan standard, you have here the completeness standard. It allows the facts and conditions to be put on notice, so Dismas Charities provided that. And in the absence of any contra testimony, and the absence of the City Council objecting to any of the evidence presented at the public hearing, which it did not, and in absence of that other contra testimony or evidence, the permit should be issued. Moving forward, in determining that, we went through a little bit of the evidence. I want to back up a little bit, because it's not just the evidence in the application that was presented, the initial application. The city staff specifically requested additional evidence to show that Dismas Charities met Standard 7. This to demonstrate that their track record in other communities and in the city of Fayetteville, Dismas Charities further provided 11 letters from law enforcement officers and 8 letters from community leaders, such as mayors and judges in other areas where Dismas Charities facilities are located, stating that the Dismas centers improve public safety in the area and provide significant economic opportunity for their communities, all of which again goes to showing and proving those facts and conditions of Standard 7, that it would allow for the protection of property values. Dismas Charities also provided documentation including an aerial map of 4 major new developments currently taking place surrounding their Nashville facility. These new developments include luxury hotels, commercial and residential uses, and event centers, showing that the presence of one of these facilities allows neighboring lands to continue to develop the uses permitted in the zoning district. To demonstrate compliance specifically within the city of Fayetteville, Dismas provided a statement that all adjacent properties are already existing uses. They provided 27 letters from potential employers, community service providers, and individual Fayetteville residents supporting the center and saying that they would believe it would increase public safety, again, allowing for the protection of property values. And additionally, they produced a sales information summary provided by a licensed real estate broker demonstrating that the average sales price and square footage price of properties near an existing reentry facility in the city of Fayetteville increased over the past 5 years.
Was that competent, just because a broker says that, or do you need an appraiser to go in there to make the adjustments? Because every house is different and unique, and then we go back to the statute that Judge Collins talked about. Is that particular piece of evidence competent?
Yes, again, going back to 393A, all evidence that is admitted without objection or trustworthy enough for the city to rely on it is competent evidence unless it is lay witness testimony as to the property values.
Well, in a real estate broker, a lay witness, because they're not a licensed appraiser. What makes a real estate broker, I mean, incompetent evidence in a trial can be considered by the fact finder if it's not objected to, but here, it has to be competent. And why is a real estate broker, why can they render an opinion on value if they're not licensed or otherwise not the owner of the property?
A real estate broker does these comparative sales studies all the time. If you think about when you go to buy a house, your licensed real estate broker is knowledgeable about the prices in the area, looking at whether your sales and price will increase over the next couple years, what the histories and standards are. But more importantly, there's nothing in the ordinance or state law that requires expert testimony in the form of an appraisal to show the effect of a special use on property values.
Can I just read this from the statute, because it says, the term competent evidence as used in this subsection shall, regardless of the lack of a timely objection, not be deemed to include the opinion testimony of a lay witness as to any of the following. A, the use of property in a particular way would affect the value of other property. That seems exactly what subsection is asking about, and it seems to say exactly that you can't have lay witness testimony. And in this case, was there an expert witness who testified?
Mr. Charleston testified on behalf of Dismas Charities. He was the attorney for Dismas Charities. That happens frequently in cases. He testified as to his familiarity of the Evans affidavit and the sales compilation summary.
So the attorney representing Dismas was also the witness?
Yes, and that's a typical practice in land use cases. Oftentimes, attorneys are sworn in, and everybody is sworn in if they have to testify. A case by this court even says while it might not be the best practice, it is an accepted practice in land use cases.
Okay, let's just say that's accepted. Is he an expert in this area then?
He's an expert to his knowledge of David Evans' testimony and of David Evans.
He's an expert as to what David Evans is going to say?
He's an expert as to the application and how it meets the standards and facts and conditions required by the ordinance.
But he's not an expert who could testify to how something would affect the value of property. For example, he's not an expert in real estate. He's not an expert in appraisals. Am I correct?
Not necessarily, no.
Okay.
However, even if you exclude the evidence of the MLS study, the cumulative weight of all the other evidence presented, the letters, the architectural design, the site plan, all of this cumulative weight of the evidence shows that Dismas met the facts and conditions required by Standard 7, that the special use would allow for the protection of property values and the ability of neighboring lands to develop the uses permitted in the zoning district.
So I have a question. So going back to the issue of the expert, is the only expert that you contend that testified was the attorney? Was there anyone else that you would contend gave an expert statement or expert testimony?
No, and The fact of the matter is that's not required under either state or city law. In fact, the city law allows the applicant or affected parties to present whatever testimony or evidence it deems appropriate. This can include documentary evidence, it can include oral or written testimony. There's no requirement that an expert testify, and there's no requirement, even under state law, under the Keenan standard, that an expert testify or produce some type of evidence for a sales study to show that the use affects property values. In fact, we would go back to two of this court's cases, Blair Investments and Sunsweet Holdings. In those cases, the only people to testify in Blair were the attorney of record, or I'm sorry, the planning director, and in Sunsweet Holdings, the owner and the attorney. In those cases, there was no other expert testimony. More importantly, Dismas Charities had a licensed real estate broker and an operator of another Dismas Charities facility present at the hearing. And the burden is on the city and other affected parties to object to the testimony and evidence presented. Otherwise, it comes in and is deemed competent. All of Dismas Charities' evidence at the hearing was not objected to and is deemed competent under North Carolina law.
I don't think, just because somebody doesn't object to it doesn't make it competent. It can be considered, but it just, because a jury can consider incompetent. In Blair, did you say that the owner testified?
The planning director, it was a staff report and the planning director.
So no, so it wasn't, the owner did not testify.
That was in Sunsweet Holdings.
Okay. Let me ask you about this before your time runs out, because you got about 2 or 3 minutes before you eat into your 6 minutes. Let me ask you about the fact that the formal written decision was not agreed to by everybody. How is the council supposed to do that? Are they supposed to come back to the next meeting and approve it again, or how's that? Why do you think that's a problem? Because I didn't know city councils work that way. They just make a vote and.
Sure. I think one of the underlying issues is, one, the motion wasn't even sufficient to determine whether Dismas Charities made a prima facie entitlement of the showing.
Yeah, what was the motion? What did they say in the oral motion? What was it based on? I guess the oral motion.
Sure. Councilor Hare made the motion to deny the permit on the fact that there was no evidence to support lowering of housing revitalization values, and that there was no evidence present that the property values and the ability of neighboring lands to develop would be negatively impacted. Again, this basis is not in Standard 7, which requires the special use to allow for the protection of property values and allow for the ability of neighboring lands to develop the uses permitted in the zoning district. Councilor Waddell seconded the motion based on her interpretation that Standard 7 doesn't require the community to represent that the special use would adversely affect their property values, and didn't think Dismas showed consistent maintenance of property values and inclination of property values. Again, these are not the facts and conditions set forth in the ordinance. In terms of the planning board order, we do argue that it should have gone back and had a full council vote, and in fact, the record indicates that had it gone back, Councilor Banks McClellan was entitled to reject the denial and would have, and the majority of the council would have issued the permit. From the outset, Dismas Charities followed the procedures set forth by the city, submitted a substantial documentation proving and showing the facts and conditions required by Standard 7 that they were put on notice at the outset. And for all these reasons, we respectfully request that the court's order be reversed and the permit be issued. Additionally, we request the court reverse the Superior Court's order granting the motion to intervene as the Doves failed to show special damages. We'll reserve the rest.
And I do want to ask you one quick question. When that motion was made, did anybody get a chance to put up contra evidence, or did they just make the motion at the conclusion of your evidence?
At the public hearing?
Yeah, at the public hearing, because my question would be that if we decided that they got it wrong, do we reverse it, or do we send it back to have a new hearing to allow people to put their evidence in? Or were they given the opportunity?
They were given the opportunity during the public hearing. The motion was made after the close of public
I
hearing.
got you. Okay, that's all I wanted. Thank you so much.
You're welcome.
Good morning.
Good morning. May it please the court, my name is Nick Tosco with Pointer Spruill, and I have the privilege of representing the city of Fayetteville in this matter, along with the city attorney Karen McDonald on the end, and intervenors counsel Amy Savon will be speaking as well, and we plan to split our time, 18 minutes I will argue, and 12 minutes Ms. Savon will argue.
Okay, and I'll keep you posted on your time. That's fine.
Thank you, Your Honor. Your Honors, while you heard several issues raised by Dismas on appeal, including an argument that they waived by not raising below at the Superior Court, the crux of this case really solely focuses on whether or not Dismas presented competent, material, and substantial evidence to show that the home values of lands around the proposed site would be protected. That is the sole focus of this case. The record is clear and supports affirming the Superior Court and the City Council their determination that Dismas failed to meet their evidentiary burden in regards to this matter.
What is the burden? Does it allow for total protection or some protection? Because I could see if you put on evidence that the building is going to look nice, that'll provide some protection. It's not going to guarantee that property values won't fall some, but it does allow for protection. I mean, it does allow for some protection. I mean, so what level is it here? Is the standard that you got to show that property values will not fall, or just that it provides some protection? I'm just trying to understand what this ordinance means, because I think the mere fact that the building looks nice and that requirement would provide some protection. I mean, it might not provide total protection, but some. So what's the standard here?
Yes, Your Honor. The standard is that they have to show competent material and substantial evidence to show that the value is protected. Now, what degree that is, it may differ. It may be that they can insubstantially injure the property, or that they can't injure it at all. The fact of the matter is there is no Keenan standard, and the reason that they are trying to assert that there is a Keenan standard is because they cannot get around the case law, specifically SBA and American Towers, which has laid out for Your Honor what is the standard in terms of protection. And the fact is that there is no Keenan standard. There is property protection standards across North Carolina. And in fact, I would say, Your Honor, that the source that they come with Dismas in terms of the property value standard needing to have specific language, it comes from a white paper authored by Professor David Owens, one of the leading experts on special use permits in North Carolina.
So what is that? What is SBA? What does it say? What is that standard? What did they have to show? Did they need expert testimony? Is that what you're saying?
Yes, Your Honor, they do. Because in order to be able to prove the protection of property values, the statute that Judge Collins pointed out requires that you provide expert testimony. It cannot be lay testimony. And importantly, none of the evidence that was received by City Council was expert testimony. They refer to the attorney who appeared before the board and advocated for Dismas as being an expert. That's simply incorrect for two reasons. First of all, the courts in North Carolina and the rules of professional conduct specifically say that a lawyer should not serve as both a witness and a lawyer in the same proceeding in a quasi-judicial proceeding such as this one. Second of all, the statute specifically says that you have to be an expert. Mr. Charleston, none of his qualifications were put forth. He has no experience whatsoever as far as the City Council is concerned as it relates to property valuation standards or impact analysis. The fact is that they needed to present competent material and substantial evidence, what a reasonable mind would show as showing protection of property values.
Now,
It may have been a
that statute that we talk about talks about opinion testimony, and we didn't have any opinion testimony, correct, of anybody, and the lawyer entered exhibits, correct? So does that mean that we're not in this statute and we're simply looking at whether the exhibits were sufficient?
Well, that's correct. I mean, the fact is that the exhibits and the letters of support and the site plan, they don't show protection of property values.
But we wouldn't exclude them as not competent because it wasn't witness testimony, correct? So there was evidence of at least on their side of some sort of protection, correct?
Your Honor, we would argue that there was no evidence of protection of property values. The only thing that could be construed as relating to property values was this one-page information sheet that was provided by a individual, Mr. David Evans, who was not only not an expert and not tendered as an expert, but didn't even show up or appear, get sworn in, or even be able to explain his supposed factual information and data.
But I just want to make sure that this statute doesn't exclude the city from considering that, correct? Because it wasn't opinion testimony, it was in fact an exhibit.
That's correct, Your Honor. There was there was no testimony from this Mr. Evans. We would argue that it is parsing the statute to say that you can consider
What we do.
I'm sorry?
We parse statute.
Yes, well, too thinly parsing then the statute to say that you can allow the one-page information sheet that is supposed to be expert evidence, but you can't have the individual testify about that.
But it doesn't say you have to have expert evidence. It simply says if you have opinion testimony of a lay witness on the value of property, that's not competent. So this statute to me doesn't say that we have to have expert testimony on that specific standard. It just says you can't have opinion testimony, and there isn't that here.
You're right, Your Honor. It does not say you have to have expert evidence or testimony in order to have property value protection standards met.
In order to meet standard 7, correct? You don't have to have expert testimony.
Well, we would argue, Your Honor, that you would not be able to prove that standard unless you did have expert testimony. It doesn't meet the standards under SBA, American Towers, and these cases where expert testimony was offered and evidence was offered that is expert evidence, and it still didn't meet the standard of a prima facie case.
So the statute just says that if you're going to offer opinionated testimony, it's got to be from an expert. It doesn't exclude other type of evidence, but you're saying our case law requires, and I can see how you could have evidence of what the building looks like, and then but you're saying that you need an expert to say, yeah, I've reviewed all that, and I think that it would affect, you still need an expert to testify what all that other stuff means.
Correct, Your Honor.
Based on the case law, the statute doesn't require it. The statute just says if you're going to have an opinion, it's got to be from an expert, but you're saying the case law requires that you have an expert to even make your prima facie case. That's what you're saying.
That's exactly right, Your Honor.
Is that required in a Keenan-type ordinance or not?
No, it does not. And
Why? Because Keenan actually, this just says you get to provide some protection of property values, which I think a lay witness could probably say, if you have something that says the building looks nice, that'll provide some protection, but the Keenan thing actually says that you got to prove that you won't diminish the value of the property. So that actually has a I mean, that to me would require more of an expert than I would think the Keenan standard would be more of an expert. You would need an expert more than this standard. Why wouldn't it? Doesn't the Keenan standard say that you've got to prove that it did not reduce the value of the property? And this doesn't have such a specific line that you got to prove. You have some quantum that you got to prove as far as number.
Actually, Your Honor, if anything, the standard that City of Fayetteville has is higher because the Keenan language, the language that was used in the ordinance, again, there is no Keenan standard. There was the ordinance that Keenan looked at that was challenged was the use will not substantially injure the value of abutting or adjoining property. That allows you to insubstantially injure the value of adjoining property. Here, Fayetteville's ordinance is protect, and there's jurisdictions across North Carolina that don't use the Keenan language. They use maintain and enhance the value of adjoining property. They use protect the value of adjoining property. And that means you have to either maintain or enhance the value of adjoining properties. You cannot injure it, even if it's insubstantially.
But doesn't this standard read allows for the protection of? That doesn't say you must protect. It says it allows for it, because certainly we can understand that circumstances might cause property values to rise like now or fall, right? So it just has to allow for it.
Yes, but Your Honor, if you look at the earlier provision of the ordinance, it says that only upon a finding by the city council that the use allows for the protection of property values can the special use permit be issued. So it is incumbent upon the applicant to meet their prima facie burden and show that somehow the use will protect the property values. It has to be something, and we have nothing here. We have zero quantifiable information, and the same leading land use expert, David Owens, that they cite for the fact that this Keenan standard has said that this competent material and substantial evidence that you need to show is a credible, quantifiable evidence. That's what you need to show. You need to show credible, quantifiable evidence, and they did not do that here. They have, at best, a cursory summary that shows some information and some numbers, but without the expert to explain that information and explain how it relates to the property values at where the proposed site is, it was insufficient under SBA and American Towers.
And why wouldn't you need an expert to say that the property values were not substantially injured? I mean, because that to me would seem to be, you would need an expert to tell you, because I could tell that might injure it, but I mean, wouldn't you need an expert to say, well, by how much? Because I guess maybe there's a legal standard, 10% might be substantial, but you would need an expert, I would think, to quantify that for the fact finder. I would think just as much as you would here. I mean, why wouldn't you under the Keenan standard?
Right. Your Honor, I would agree that you would need to show some protection. You would have to have an expert.
Would you think you'd need it under Keenan?
I'm sorry?
Keenan? Would you need an expert under Keenan to quantify whether or not something was a substantial injury or not? Because you said Keenan said you can't do something that would substantially injure. So why would you think you would need an expert for that?
Yes, Your Honor, because I think that...
But our court said you didn't.
Well, the city council is the one that has to determine whether or not a reasonable mind would consider this as protecting property values. The city council is the one that has to decide what that degree is. Is it 10%? Is it 15%? Whatever it is.
But would you need an expert to tell you, did it reduce it by 15% is my thing. Okay. Once they set whatever that number is, wouldn't you still need an expert to say whether or not this would fall below that or not?
Yes, that's the safest way to do it. And my
But
years
is
of
it
practice.
required? Because you said our case law does not require that under a Keenan standard.
Well, Your Honor, I would say that under the Keenan standard or under, which again, there's not a Keenan standard, but regardless of what the language is, the property value protection standard, that requires a certain amount of evidence that can show no impact to property
Would
values.
it need opinion testimony from an expert in either case?
Yeah, that is not required in the statute, but that is what is the safest and most sure way that a city council is going to rule in your favor and say you've met your evidentiary burden. Otherwise, you run the risk that you're going to get there with just showing site plans or layouts, and that's not going to be considered protection of property values.
Can I ask you, was that site plan that we just saw, is that competent evidence? Were they allowed to, was the city council allowed to consider that?
Yes, Your Honor, that did not, and that was not incompetent evidence, but it did not go to speaking to showing the protection of property values.
So if a city councilman looked and saw, wow, there's this buffer here, there's a 10-foot buffer all the way around the property, there's this tree buffer here, this faces the road, there's no extra traffic, can the city council consider that?
Sure.
Okay.
Yes.
But it's your contention that the city council couldn't consider that to be substantial?
Your Honor, I would say that doesn't show the protection of property values by itself.
Why not?
Why not?
Wouldn't it show the protection, but just not the degree of protection? It shows protection, just
That it allows for protection?
Yeah, it allows for it would show some protection, but just not the degree of protection. Just like in the Keenan statute, you could have evidence to show it was injured, it just doesn't show the degree of it. You would need an expert probably for that to come down to the real number, but is that required? Because it just has to allow for the protection. Why can't a lay witness saying, yeah, a buffer there would allow for some protection. So that's where I'm trying to understand what this ordinance means. Does it require a certain degree or just some protection, which I think, you know, the lay witness could probably figure out. They may not know the degree, and you would need an expert for that, but is that required to make your prima facie case that you met that section, I guess?
Your Honor, I would say that a lay witness under the statute can't testify about any degree of whether or not there's a property value.
But whether or not something would protect to some degree, you think a lay witness could say, yeah, if you have a buffer around that, that certainly would provide some protection. I can't tell you how much it would because I can't get comps, but I know that's something, like I think a lay witness could say a bigger house is worth more than a smaller house. I don't know what you would need an expert to say to quantify that, but at least but maybe a lay witness or the city council, because it's just in the natural, I mean, it's just something that people would know that if it's a bigger house or a newer house or brick rather than, you know, straw, it would be more valuable, but maybe not know the degree. So I'm trying to understand, but you're saying the case law requires you have to have an expert to say that what the degree is, I guess.
Yes, Your Honor, because just saying that the site plan will protect property values is not enough to overcome your evidentiary burden that you provide competent material and substantial evidence. That's credible quantitative evidence. That is what you need to have an expert for, and they did not have anything to show that at all.
Now, I just heard you say a little bit ago that the statute and the ordinance doesn't require expert testimony, but that would be the best practice and the way they should have proceeded. But now I'm hearing you say, well, they needed expert testimony. So exactly what was the city looking for here?
The city was looking for competent material, substantial evidence to show that the property values around where the proposed halfway house would be located would be protected. And in fact, on pages 163 and 164 of the record, Councilmember Waddell specifically tells Dismas that that is what they were looking for. They were looking for some correlation between what this one-page information sheet showed and what is happening on the property values where the proposed halfway house is going.
And didn't the real estate broker speak directly to that particular issue?
I'm sorry.
The real estate agent, didn't he speak directly to that particular?
No, he did not, Your Honor. He did not show up. He was not tendered as an expert. He wasn't sworn in. For all we know, he was not even there, even in the audience, Your Honor. It was Mr. Charleston who was trying to explain it after the fact and tell the city council that this standard was met. And those were legal arguments. He said several times throughout the hearing, my client, and advocating that the legal standards were met. And the fact is that they just did not meet it. Your Honors, I did want to quickly address, before my time is up, the written decision issue. We would argue that...
You can take about 3 minutes because we ate into your time.
Thank you.
I do want to hear this. Go ahead.
There are two main reasons why this court should not be considering that new argument. First of all, they waived any argument that the written decision was invalid for some reason because it didn't go back for a second vote. The waiver rule... They
didn't make that argument at Superior Court?
Correct.
Okay.
In their petition or in their brief to the Superior Court, there was never any argument that 160D, the new legislation, required the written decision to go back for a second vote. That was a new argument that was waived, and it should not be considered by this court.
Okay.
The second reason, Your Honor, and this is important, is that the new 160D legislation that they cite that has this requirement, which is, it's unclear whether or not there really is a requirement that it go back for a vote of the board, it had an effective date after the decision in this case. The legislation states that the effective date initially was January 1st of 2021. It then was pushed out to July 1st of 2021. But regardless, the written decision here was in March of 2020, well before the effective date took place as it relates to...
What if the oral motion was based on X, but then the one that the mayor writes says Y? I mean, what do we do? What do we review? The findings made in Y, or do we look at what was actually said?
Your Honor,
can we ignore the first one? I mean, the second one? What are we looking at?
Your Honor, you can look at both, but the statute says that the chair of the board or the mayor is the one that is authorized to look at that written decision when it comes before him or her and decide whether or not it follows what the vote was before the city council. And if they write findings of fact or conclusions of law that don't line up to that, that's something that could be considered. But here, it does not require, and again, the leading land use expert, David Owens, has a whole section on this in his treatise that says that the common practice in North Carolina is that you look at the written decision and the mayor or the attorney who writes it signs it and make sure that it lines up with what the vote was. Your Honor, I would like to let interveners counsel, but the city would respectfully ask that you affirm the decision.
Thank you. And you have your whole 12 minutes. I interrupted a little bit. Thank you. Don't worry about the lights. I'll let you know.
Thank you. May it please the court, my name is Amy Savon, and I represent the interveners in this matter, Cynthia and Erlis Dove, who own property right beside where petitioners have proposed to put this 15,000 square foot halfway house that could house up to 100 inmates. Want to first start off with the directed verdict standard. We agree that what has to be put forth here has been compared to a directed verdict standard. And what the Supreme Court said in the recent PHG case, you know, they made clear that the burden was on the petitioner to make sure that they first made their prima facie case with competent material and substantial evidence, and that it had to be substantial and not just the mere scintilla, that they had to come forth and make their case. And that has to happen first before any burden here switched for there to be any contrary evidence put on. So here, what interveners contend is that the burden never happened here because they never met their prima facie case. Yet at the hearing, Mr. Charleston testified, oh, well, you haven't seen any contrary evidence showing that there would be an adverse effect on property. But the burden never shifted because they had never made their prima facie case.
So you think evidence that there's going to be a nice 200-foot buffer between this facility and your clients' homes does not allow for the protection of their property values? That's not enough?
That's correct. That's not enough. There needs to be, in order to meet both the competent aspect of it and the substantial aspect, there needs to be some type of analysis done. There needs to be an engagement that reviews what's going on with the property, with the proposed use at issue, and what that effect is going to be on the adjoining and nearby areas to know whether or not it's going to protect the property.
Isn't it enough to show that the same type of structure hasn't negatively affected properties in other similar situations? Isn't that the only way we can really know, is to analogize?
That can be part of the analysis. However, in both PHG, this court, when they reviewed PHG and were looking at SBA and American Towers and what was different, pointed out that in SBA and American Towers, part of the reason those comparisons failed was because they didn't also talk about what's going on here. They only talked about what happened somewhere else. So the happening somewhere else in a similar circumstances could be part of the analysis, but again, the issue is on the property adjoining. So there also needs to be an additional aspect of that analysis done that includes the property that does surround the property at issue. Additionally, Your Honor, the comparison used here with the halfway house, and part of the reason it's insufficient, and I'd like to show this page from the record, which is page 325.
Just turn it around.
Stand around there. Sorry.
Thank you.
Thank you. What was submitted by Mr. Evans, one of the reasons, it falls short for many reasons, but one of the reasons it falls short is because what Mr. Charleston explained about the halfway house here, that's nowhere in the analysis, is that the halfway house at issue was significantly smaller, and it was located in a shopping center. So without someone like an expert who is an appraiser discussing, well, yes, this is smaller, but it is analogous, and it would be relevant to what would be going on here with this halfway house, that's completely missing here. So we don't know how they took in the differences and the similarities between what would be going on at this proposed halfway house to know whether or not we can look at information such as how was the property affected in the 5 years since this has been in place. So the analysis aspect here is a required part of meeting competent and material and substantial evidence when you're talking about what's going on to the property values, and that is
I just
missing
want to
here.
jump in and ask you about the special damages to your clients. I didn't see from the record what exactly those damages were and how they were different from anybody else on the same street.
Yes, so as the interveners here, here, I'll switch this out for a different one, a different page from
And
the record.
it's true that simply being an adjoining piece of property is not enough, am I correct?
That's correct. That's part of it.
Part of it, but it's not by itself.
That by itself is not sufficient. And what has been deemed to be sufficient here, where it's a special use permit, that's at issue. The being a nearby property owner where it's some unique special use, this situation is similar to what the Supreme Court reviewed in Mangum, where there was a proposed adult establishment. And in addition, they looked at the interveners there, brought up, well, there could be parking issues and safety issues, security, noise. And here, my clients indicated that there were safety concerns that they had because they were the adjoining property owner, and then the adjacent property, and then just having the additional 100 persons living there would have additional noise and such. And so the impact to them might be what people who also live further out might say, but the substantial impact to them as being the specific next door neighbor to this property would be sufficient to allow them to have standing due to the potential special damages that they would incur were this halfway house be built right beside their property. Briefly, I want to point out that the Blair Investments case, that was not on a property value standard. What was at issue in Blair Investments was that the proposed use would not endanger the public health or safety, and that involved a tower there, and that it would be in harmony with the surrounding area. So this whole issue of, well, what do you need to meet the property standard wasn't what was on appeal. So that didn't get addressed presumably by the parties in their briefs. The SunSuite's case actually is instructive. There, the burden did switch, so what was on appeal was not whether the applicant had made their prima facie case, but the burden did switch, and so whether the contrary evidence was competent, material, and substantial. And they're similar to what we have here as far as the petitioner's side, is one speaker said that this court said that they may have been qualified based on their profession, but all they presented was a naked opinion and didn't have factual data or background information such as market studies or appraisals to support what it was they were actually saying. So this court has said speculative assertions are not enough, and what is in, I'm sorry, wrong one. What was in the one pager doesn't even have a naked conclusion. All it has is show that there were properties at some place near a halfway house where the values, in fact, did increase, but they're not benchmarked to know, well, how were they increasing before the halfway house? How do they compare to other parts of Fayetteville? So that just the lack of the analysis here is what makes this insufficient on both the substantial and the competent aspects.
You still
Thank you, Your Honor.
You still got 4 minutes. Don't pay attention to that because you started late.
Okay, thank you. So I'm sorry, how many minutes?
4 minutes.
Oh, okay.
Yeah, till 10:32.
So we would indicate that this court's case law is very instructive on what is necessary to meet the competent, material, and substantial standard. And the wording of this case even though it's worded slightly different, the meaning is substantially the same. There still must be competent material and substantial evidence, and when you're evaluating property issues, that means there has to be some sort of analysis, typically by an appraiser who has done an actual appraisal where they've done the analysis and they have put forth actual conclusions on what is the impact of a similar scenario, and what is the impact on the property at issue. What do they
But
project
you would
that to be?
concede that not building the building right up to the property line, but providing for this buffer allows for some protection of the property value, or do you need an expert to say, yeah, having a buffer is gonna reduce the impact? I'm not saying it doesn't impact it, and maybe they have to show that it doesn't lessen the value rather than, but doesn't that provide some protection? I mean, the fact that their site plan approval allowed for this big buffer between your neighborhood and their building?
Yes, as part of their application where they show the site plan, that definitely gets to why they're trying to convince the
So that's
city
some
that they
evidence.
have
You're just saying
done.
you're just saying it doesn't it doesn't reach the level of prima facie. But
That's
It
correct.
is evidence, and it's evidence that the council can consider, because it does provide some protection, but you're saying it just doesn't meet the prima facie.
Right. There needs to be some aspect of an analysis that's going on, or either testimony by an expert who can actually, based on their expertise, can talk about why the value is going to protect properties. And so for all those reasons, this here was just severely lacking.
You still have about a minute and a half, so go ahead.
Thank you. When this court's other cases are looked at, again, using very similar language where you have to protect values, it's clear that no other case has let this minimum amount of so-called evidence be sufficient to show the protection of property values. And so what they're really asking you to do here is set a new, just bare minimum standard. And that would be the scintilla of evidence, which PhD said you had to have substantial evidence.
I have a question for you. You keep referring to the one page as the only evidence that was presented, but wasn't there plenty of affidavits that were presented in advance to the city council, as well as 100 pages of other information?
The only thing that dealt with value to the property specifically and how surrounding areas benefit property was that one-page MLS sheet. The Nashville area is again talking about an area far removed, and there's still not an analysis. It's still just a little paragraph that indicates that Nashville, which people know as a very booming city, that there's also been booming there. But again, there's no expert to say, well, look at Nashville. It's in this area, this specific area of town. We've seen this and that as far as property values. In this similar area of Fayetteville, you can expect or not expect the same things when you calculate what actually is in that area in Nashville. That, again, is very lacking. It's just a minimum paragraph, and it's still missing the analysis to meet the competent material and substantial basis they needed to make their prima facie case.
So is it your contention that there must be some sort of numbers analysis? Because when we read Standard 7, it says allows for the protection of property values. Must there be some sort of, I guess, evidence of the number? Or is it simply what is done to the building that will clearly protect values, whatever they may be? Does that make sense?
Yes. I don't know that it has to have necessarily numbers. That would certainly be helpful. As we as attorneys and you all as judges do, we analyze things all the time with using mainly words. And you go through the compare and the contrast through that, and that way you're able to provide an analysis, usually by somebody qualified in doing such a thing would be what would be needed. But that way you have something to base it on, and not just a mere conclusion, or not just a little bit of information and not understand how that's applicable to the situation at hand.
If you want to spend 30 seconds wrapping up, you can.
I think
That's
I'm good.
absolutely
Thank
fine.
you, Your Honors.
Thank you so much. We'll hear from the appellant, and you have 6 minutes.
May it please the court, I'm John Cook. I represent Dismas Charities. I just have a few things I'd like to direct the court's attention to. And first thing is, there's been a lot of discussion about case law and Professor Owens. But every case that's been decided by this court, that's been cited, and Professor Owens himself, have been talking about the Keenan standard and not the standard that's before the court today. That is important because the Keenan standard says two very specific things. You are to judge the value of adjoining or abutting properties, and two, it's a measure of damage, substantial injury, no injury. You'll see them kind of vary. That's the standard in North Carolina, and that's the standard of your case law. The city here has adopted a completely different standard, which not only talks about allowing for property protection of properties, I don't know what properties, but it also talks about the development of property allowed under the zoning ordinance. That's one whole continuous condition. It's entirely idiosyncratic in that regard. I think the question before the court and the way to get to the answer before the court here is to go back to exactly the case that has been discussed before, which is the Supreme Court case of PHG, decided in 2020. And this is, I'm going to read, I don't like to read, but I think it's kind of important to read on this one, because you have a new standard never faced in North Carolina. The property before you is appropriate for a reentry center upon the proof of certain facts and conditions, and this is the Supreme Court's words, detailed in the ordinance. If you had a detail as to what properties you were worried about, as you had a detail of what that means allowed, then the applicant would be on notice, because the Supreme Court also says to hold an applicant must first anticipate, approve, and disprove each and every general consideration would impose an intolerable, if not impossible, burden. That's why they have to detail it. The notice of the facts and conditions required by Standard 7 arose in two ways. One, the language and structure of this single standard. And we did our very best to answer what that was. And the second way it arose was that the staff looked at the application and said, this satisfies the standard. You do have cases on completeness, and they have been cited to you, and some of them hold that the city is bound by that. And the reason the city is bound by that is the notice to the applicant. You have done your homework. You have the facts and conditions that you need. And I would point out, this is the professional planning staff. This is a standard that's about planning, and it's not about appraisal.
Are you saying that if a permit application gets to the city council, it has to be approved unless contra?
No, it doesn't have to be approved if there is competent evidence.
If there's no contra, would they have
it must be approved, and that is the teaching of PHG.
So they're bound by whatever their staff says?
If it's a prima facie case that tends to establish those matters, they are bound unless there's competent evidence. And I believe Judge Green has said that in a case that's cited in the briefs where there was a completeness standard requirement. But the point here is, regardless of whether they're bound or not, this is a property owner who is entitled to notice of what facts and conditions are required by the standard, which is inherently
So what do you think is required by the standard? What's required by this standard?
The facts and conditions that are required by the standard to be able to come in with the evidence before a hearing and present it.
No, this standard 7, what does standard 7 require? How do you interpret standard 7?
Standard 7 requires exactly the evidence, exactly the facts and conditions that we put in our application, and that was determined by the staff, and the staff recommended approval. And to be substantial evidence, it just takes a reasonable person. We would suggest to you that the professional planning staff is a reasonable person.
So you don't think 7 requires that you have to quantify how much it affects, just that it allows for some protection?
The simple answer is, if they wanted an appraisal, they needed to detail that in the ordinance sufficiently to be clear about that. That's the difference between Keenan and this standard. Keenan, you can offer an appraisal on the ultimate question. does it affect property adjoining or abutting? You can't do that. I can't even give an assignment to an appraiser as to what property to appraise. And secondly, an appraiser has no competence to talk about what a zoning ordinance allows. That's not in their scope. And consequently, all you have is this indirect evidence. I admit it's indirect. Everything is indirect. But the point is, it is their duty to put us on notice, and the only way we had notice was the language of the statute. We kept on submitting information, and they said, yes, that's good enough. And then, I might say further.
And you have 1 minute to wrap up.
Yeah.
Go ahead.
So under the statutory standard, Judge Collins, our evidence is competent, material, substantial, shows a prima facie showing. The evidence that's excluded by that is that oral speculative testimony of neighbors, and that is the Woodhouse case from the Supreme Court. Speculative language is excluded. Accordingly, I might say, in a quote to the Supreme Court, the local government body lacks authority, quote, to deny a permit on grounds not expressly stated in the ordinance. That's the law in this state, and we ask you to apply that. The confused...
I just want to clarify. Your argument is that once the city planning board says that this is complete, that is prima facie the case, and that the only purpose of the hearing is then to allow contra evidence to determine?
Once the professional staff, not an advisory recommending
Right.
board,
The staff.
once they have been authorized by the government to go and make this completeness determination in their ordinance, and they've made it, that is a determination of the facts and circumstances required under Standard 7 by the government. It is notice to Dismas that you don't need to do any more because you have satisfied these standards. And consequently, it is a prima facie showing because they are reasonable people authorized under law to do such a thing.
And so your argument is that PHG says exactly that?
PHG is at the beginning of all things. We're in a government proceeding. I own property. I have a right to use my property. I want a permit. They've got to give me enough advance notice as to what facts and conditions I must prove. This standard doesn't do it by itself. I could sit here and read it all day. You could read it all day and it doesn't tell me what I'm supposed to produce.
Isn't that the problem with a lot of these standards, like harmony? Harmony's, who knows what harmonious with the surroundings is?
I think that's correct. And I think, back to your points. Look at that. Look at all that preservation. And I might say their own mayor order said this facility is as far away from the residential property as possible. To meet their standard, we can't meet their standard. If we put it as far away from the residential property as possible and preserve all this woodland, we say that's a prima facie showing. Can't do any more than that. And they're presumed that if I'm zoned for this property, I can use it if I show the facts and conditions. So what happened here was there was a confused oral motion, which you can read the motion, doesn't make any sense. It doesn't have anything to do with this standard. And the minority overruled the majority because they said they had to do a reconsideration and have a supermajority vote. Well, let me be very clear about this. The mandate from the General Assembly to this government for more than 40 years has been that permits are decided by majority vote of the board. And in their ordinance and in state law, to be a decision, it must have certain required elements, and that motion does not meet it. They had a duty to take it back to the board. They very well understood that if they did, that motion would have failed, and this permit would have been issued. So respectfully, and I appreciate Your Honor's patience on me, respectfully, we would ask the court to reverse the Superior Court and to order the city to issue the permit. We were entitled to it long ago. Thank you.
Thank all y'all for your great arguments. We'll take it under advisement, and this is the only case we're going to have orally argued today, so we'll adjourn. Will you adjourn court, please?
All rise. This session of the North Carolina Court of Appeals is adjourned.